All right, welcome back to From A to Franchisee. And today's episode is about red flags in a franchise agreement that most buyers miss. Today, we're going to go deep on something that I think is the most underestimated step in the entire buying process, and that is the importance of what you're signing in that franchise agreement. If you've been listening for a while, you may remember our episode with Tom Spadia, where we spent a lot of time on the FDD, which is the franchise disclosure document. It's a great foundation for today because the FDD tells you what you're getting into, but the franchise agreement is what actually binds you to the brand. It is your contract for the next 5 to 10 years of your life. And most buyers treat it like a formality. And today we're going to change that. I'm joined by Megan Center, counsel in the franchise and distribution group at Faegre, Drinker, Biddle, and Reith. Megan has nearly 15 years of experience as a franchise attorney, advising franchisors at every stage of growth, from emerging brands to large established systems. She also represents buyers, sellers, and investors in franchise mergers and acquisitions, which means she's been on both sides of this document. She's written these agreements and she's reviewed them on behalf of franchise buyers. That's dual perspective that we are going to bring to you today. Megan, thank you so much for joining us today.
Thank you so much for having me.
We're excited for your expertise. So before we jump in, tell us a little bit about your background in franchising and what really drew you to this specialty of law that you're practicing.
So I think what happened to a lot of people is I just kind of fell into this industry. In college, I had no idea that this existed. In law school, I had no idea that this world, this industry was as large and massive and fun as it is. So I graduated from law school in a time where the legal market was not great. I moved out to my current residence, not knowing anyone, not having a job, and the franchise world was one of the first ones that offered me one. And I always enjoyed the intersection of regulatory law and the contract drafting. I knew I wanted to end up on the transactional side. Litigation just was not for me. This opportunity presented itself, and I am so happy that it did. I
Me
just
too.
can't imagine not being
I
in it
know.
now
I know.
at this point. And it's such an interesting area of law that gets to touch on so many different things, and I'll talk about that a little bit more.
Awesome. I love it. And we had the opportunity to work together on the Women's Franchise Committee for the
Yes.
International Franchise Association. So I'm so glad you fell into franchising, that I fell into franchising, and then we connected through that committee
I
because
adore
that
you.
was the best.
Yeah,
Okay.
absolutely.
So on the podcast before, we've talked a lot about the FDD, just trying to kind
Okay.
of simplify it for people that aren't familiar with franchising. But today we're going to
Sure.
focus on the agreement. For
Yeah.
anyone that hasn't listened to the episode yet, can you just explain the difference between the FDD and the franchise agreement so that we can kind of highlight why this deserves its own episode?
Oh, absolutely. So the franchise disclosure document gives you all of the information you need about what the offering is. So it goes through everything about the franchisor, their background, the executive team, how much it costs, how much you may be able to make, all of these different things about the offering. It also provides kind of a high level summary of certain portions of the franchise agreement. The contents of the FDD are governed by the FTC rule at the federal level, and certain states also require certain items to be in the FDD as well. But the franchise agreement is the actual binding, like you said in the beginning, the binding agreement that governs the relationship of the parties going forward. When you sign the franchise agreement, it's not as though the FDD goes away, because there is available opportunities for claims in the event that the FDD was untrue, misleading, those things. So it doesn't really end there, but the franchise agreement is really what governs the ongoing relationship between the franchisor and the franchisee during that 5, 10, and then if you renew, 20, 30, whatever year period that you're operating this business. So I think it's as important, if not more important, because of that.
Yeah, good. So in your experience, how many franchise buyers do you think actually read the agreement as
Oh,
careful as you would recommend before they sign off on it?
I would say not
I
enough.
know.
I think there's a lot of heavy focus on the FDD itself, which is a good starting point, particularly because it is written in a way that's not legalese. It has to be written in in plain English. So it's easier to digest and read. But if you look at the parts that actually focus on the actual language of the franchise agreement, it's very minimal compared to the 60 to 80 page agreement you may be signing. There are a lot of nuances in that document. And from my perspective on the drafting side, it's always drafted heavily in favor of the franchisor.
Right.
So it's
Which makes
incredibly,
sense because they're
of course,
protecting this brand. And if
absolutely,
you buy into the brand, they're protecting your investment when you go to exit the system. So there's a
absolutely,
reason it is skewed towards the franchisor, and that is really to
absolutely.
protect your business. Yeah.
Yeah, and at a certain point, you just need to understand, even if you're not negotiating, even if you're not trying to change any of the terms, you just need to understand what you're signing and what you're signing up for.
Yeah.
Truly.
Yeah. I think about when I signed my first mortgage and I was like, I don't even want to read anything. Like, just get me through this massive document. Seriously, I was like, I
I
assume
read
that this
the
company
paperwork.
is big enough that they've done this 100 times and I just signed
I
my
know.
life away. It turned out well.
Yeah. So glad it turned out well for you. But I actually
Okay.
read a lot of my mortgage documents because 'cause I'm
Yeah.
a weird I
Yeah.
just
Okay. So we're going to talk about some red flags and things
yeah.
to look for in that agreement.
Mhm.
Do you want to just kind of start with the list that we shared with you ahead of time, or do you want to start with what you think is the biggest red flag or area to focus on in the agreement?
I thought your list was good, so why
Okay.
don't we can start with the list, and then from there, there may be offshoots.
Perfect. So let's start with the territory rights. I think that's a
Yeah.
big part of why people are buying into a franchise. What
Mhm.
should a buyer be looking for and how their territory is defined? And then what do you think are some red flags or warning signs that should kind of put their hackles up?
So the first thing is, what is the area in which you are looking at? And looking at how close the territory is or the proposed area is going to be to other units within the system and then other competitive businesses outside of the system. So at the start, how big is the territory? And I think from there, what you also want to look at in the FTD, and not to tie it back to there, but making sure that the territory size is in line with any financial performance rep that is in the FDD. Because if the territories were much larger 5, 10 years ago, and it's not representative of the size of the territory today, that's something that you would want to look at. But outside of that and the size and the location, because oftentimes it is not formally determined at signing of the franchise agreement, because if it is a brick and mortar, you don't know where the unit is actually going to be when you sign it. So understanding the typical size is very important.
Yeah.
From
Yeah.
there, you wanna understand what are the protections that you're getting, and then what are the protections that or what are the rights that the franchisor is reserving. So, typically, a territory a franchisor is going to grant and say that they will not locate another affiliate-owned, corporate-owned, or, franchise unit within your territory. That's what we would deem, exclusive or protected. So, understanding if that's the case at the outset. And if that's not the case, what does that mean? Does it mean that they could locate someone literally next door to you? They could. Now, will they actually? You don't know because they obviously don't want to cannibalize a unit. They wanna make sure that everyone is able to grow, so probably wouldn't be the best practice, but making sure that that rate is in there and you understand if they have the ability to do so. The second big point. Sorry, go ahead. Do you
Well, I
wanna
was
add?
going to say, so just on the territory, so you
Yeah.
mentioned the big territory to small. I think it's good to explain. Sometimes when franchisors start, there's less
Mhm.
franchisees, zero franchisees in their system. So they give you this big territory because one, they probably don't really know what they're doing. And two,
Right.
they just want to bring buyers on. So they're promising a larger territory. They won't change that on you within your agreement. When you come up for renewal,
Mhm.
they might
Mhm.
look at your performance, where your customers are coming from, and decide that it makes more sense to make it smaller. So, really and truly, the best protection you can have as a franchise owner is really work your territory because then
Absolutely.
that's going to be better for you when you come up on renewal. So, I just wanted to explain that. And then also, some franchisors have a model where they don't give you protected territory, correct?
That's correct. That is
Okay.
that is correct.
Are we
Yeah,
seeing that
absolutely.
less now than we used to, or is it still the same? Some people just think, especially if it's not brick and mortar, that it's population based and that there's enough business in that area for multiple franchise owners to come into it. Do you see it as much? Is it less? Is it happening less?
I see it less than I saw 5 to 10 years ago. I see more systems and more of franchisees, frankly, demanding that there at least be some limited amount of protection. Um, and it sometimes is referred to, particularly in service-based when there's not a brick and mortar, as a kind of a marketing protected area. So maybe some of the territories will overlap slightly or be really close to each other, but a franchisor will not allow a franchisee to market or solicit in another franchisee's area,
Okay.
which is also incredibly important.
Yeah. Yeah. Absolutely. Okay. Continue on. I just wanted to kind of hold up that
No, please.
territory.
So the other side of things is what the franchisor reserves the right to do. Oftentimes these agreements are drafted when the franchisor is quite small. So in my practice, I advise my clients to make sure that they reserve the right to do any and everything that's not granted to the franchisee. This means starting a new system that could be offering competitive services under different marks. If it is a food-based quick service, making sure that they have the right to do online sales directly to customers via their website. So lots of different things that the franchisor may not be doing at this moment, but that they have the right to do in the future. One that has come up incredibly common because of private equity getting involved in the franchise space is the ability to be acquired by or acquire another competing brand, which could have units within the territory. So think of any of the conglomerates that exist out there. Part of the diligence that I do in my M&A world is making sure that we're not breaching the franchise agreement by having units that are deemed competitive with the system that's already owned, um, and having that acquisition close. So those are all standard reservation of rights that I see. I would say that a franchisor has never or should never negotiate those rights, but it is important for you to understand a franchisee that's coming into a system, what that means for you.
Yeah. Okay, so this is called territory rights and encroachment. Can you explain what
Sure.
encroachment means or give us an example of what that looks like from a franchisee's perspective if it happens?
Yeah, so I would say anyone that's trying to market in your territory, solicit a customer in your territory, and encroaching on your territorial rights. So, in the event that you are granted an exclusivity, in the event that another franchisee within the system comes in, markets, solicits, services someone else within the territory. So what you would want to understand is, does the franchisor have a policy in place if that happens? What are they going to do? Are they going to step in? Are they going to protect you? Are they going to take the steps to make sure that they're actively protecting the rights of your territory? Now, that's a good question that I would say to ask not only to the franchisor, but when you're doing your diligence and calling the franchisees that are in the system and even the franchisees that left the system, does the franchisor monitor this activity and protect the rights of all of the franchisees within the system in
Awesome.
that way?
Okay, so you mentioned the franchisor having the right to do e-commerce in the future or sell
Mhm.
directly to your customers. What kind of questions should we be asking or looking at as far as what does that mean for sales that are happening from my territory?
Very good question. What I always say is that typically the e-commerce sales, particularly in the food space, are not the typical customer that or not the typical person that would be taking away a customer from a quick service restaurant or thing like that. So a good example is any restaurant has, in the frozen food section, different things that they may offer within their restaurant, but now they have a frozen version of it. It's not the exact same thing. How I tell my franchisor clients to pitch it to the franchisees is that, okay, we're maybe getting another person exposed to the brand, exposed to the food item that may make them want to come into the restaurant instead. So I don't view those as directly competitive per se, but it is still something that is a right that the franchisor reserves. So asking the kind of questions about what is currently out there on in the e-commerce space, what do they sell online? Um another example is soap making, and then one of on the e-commerce site they can sell directly to the consumer. If you're doing a soap making business, typically it's a whole experience.
Right.
So you go in, you smell everything, you get to pick your scents, you do all these different things. So I think um the franchisor should pitch it in a way that is demonstrating the increase of sales and the increase of exposure to the brand. But on the franchisee side, you want to ask what those activities are. And more importantly, do you derive any revenue
Yeah.
from the sales that are made in the territory? 99% of the time, you are not going to.
Yeah, yeah, and so a well-known case of this is when Dunkin' Donuts decided to put their coffee beans in stores, and the
Mhm,
franchisees did not react well to it.
mhm,
And then I think they moved forward and did kind of a rev share model. But the other story is Aroma Joe's, and they're also a coffee place, but they do these rush drinks that people are nuts
mhm,
for. And when they
mhm.
started selling them in cans in stores,
Yeah,
it actually increased traffic to the physical stores. So you could also think about this as a marketing cost and awareness.
absolutely.
So yeah, so it can go well and it can not go well, but I think just understanding that as you go into the system, what it looks like.
Yeah, and I think if the approach that the franchisor has is that there's not a rev share model, this is another one that I would say the franchisor is not going to
Right.
negotiate on
Yeah.
because they're not going to make a one-off exception for such a large part of the business.
Yeah, absolutely. Okay, next let's talk about the renewal terms and fees. So we're talking
Yes.
about a 5 to 10 year agreement that you first sign.
Mhm.
What happens at a renewal that buyers don't anticipate or don't know from when they sign that first agreement?
Absolutely. The one term that it should always be in there, and I mostly see it, is that when you renew, you have to sign the then current form of agreement that they are offering to new people at the time of signing, which could mean differing fees, um, differing software, computer, all of those different things. Um, and it could also give them the right to adjust the territory size. So circling back to what we were talking about the territories, a lot of systems for the legacy units that were granted kind of these very large swaths of land because they were brand new, oftentimes the franchisor at that point will try to take advantage of the opportunity to revisit the terms of the agreement and say, okay, the territory size is this now. So now you either have to break this up into three, or we're going to cut down the territory and it's going to be more in line with what we're offering today.
Yeah, so they're gonna say,
That's
"You're
that's
paying
number one.
for these other 2 territories we've created, or we're gonna sell them to someone else." That's typical.
Correct.
Yeah, okay.
Correct. And with the fees, there could be new minimum performance standards that were not in there before. So making sure you understand if you were not subject to them, you may be now, or if you were subject to them, they may be different on renewal based on the fact that it's already an operating unit.
Yeah, and that could be technology fees, marketing fees, you could see any difference of what they
Anything.
didn't catch that first time, they've added in since, will get added to yours. How
Absolutely.
about renewal fees?
So I was just going to say a good way to look at that is just to ask for a red line copy of the franchise agreement. So you can say, hey, I signed in 2020. I want a red line against the 2025, 2026 version whenever you're renewing. So you could quickly identify each of
Oh,
those
awesome.
things.
Okay, so the franchisor will provide that to you.
I mean, they should, but yeah,
Okay,
you can ask.
okay.
That's an easy way to do it.
Okay, so how about renewal fees? Are there always renewal fees? Are they standard? What do those look like?
There are not always renewal fees. Our good friend Paul Pickett does not have a renewal fee in his wild birds, and he said that I had to shout him out because I told him I couldn't do a call until later today. So there's my shout out to him. Um, Typically, I do see a renewal fee though. What I tell my franchisor clients is not meant to be a moneymaker. It's meant to recoup the cost that the franchisor incurs in connection with approving the renewal. So typically, depending upon the type of business that's going to be the franchisor, maybe doing an audit on site, maybe doing an evaluation of modernization requirements, anything like that, the franchisor having to provide additional training. So typically I either see it as a flat amount, five, $10,000, or a percentage of the initial fee. So it's so
Okay.
as the initial fee grows, that fee grows slightly, but it's usually not more than 25%
Okay.
of the current initial fee.
Yeah, and you brought up a good point is that franchise brands are, if you have a physical space, tend to go through
Mhm.
remodels because they want to keep it a place that customers want to come into. So if
Correct.
you've not done any of those remodels, it will be usually a contingency of that re-signing that you do it. We lost our local Dairy Queen because of that. It was very sad.
Oh, really? I
Yeah.
love driving around and seeing the differing signage
Yeah.
of those because now that we're so exposed to the industry, we know why all these signs are so different when you drive through and see
Yeah.
such differing signage.
Yeah, yeah. How about any of the stuff that we just talked about in the renewal thing? Any of that negotiable or you're gonna see the same thing?
Um, One thing that I have seen go through is if you request on the request to sign the then current form of agreement, I would say a franchisor is probably not going to agree to waive that requirement. However, what you can do is say, I want to keep my territory and I want to keep my fee structure. So those are two things that you can kind of guarantee that I have seen, so that you're not paying a royalty of 7% of gross sales now, and all of a sudden it jumps to 9, 10, whatever it may be upon renewal. So that's two good things that can give you a little bit of comfort as you renew. You can try and put a cap on the modernization requirement. That's a little bit more difficult to determine just because you can't predict the future as to
Right.
how that unit is going to be at that point. So you can try and do that, but generally those are the things that I would um, request. The other thing is the renewal condition is probably that you have to be in compliance with your franchise agreement at the time that you renew, at the time that you request to renew, at renewal. And sometimes it'll even say that you've had to comply with it during the entirety of the franchise relationship, which is a long period of time. One little um misstep could technically be a default. Now, there are state laws in place that protect against, you missed a payment 1 month out of a 5-year term. Is that really enough to not renew someone? Probably not. But you can try and say, so long as the franchisee has substantially complied with all of the terms of the franchise agreement and cured any defaults during the term of the agreement, that's a good way to add a little bit of a layer of protection for that specific renewal condition.
Yeah, and I would say too, franchisors aren't looking to default franchisees. It's an expensive, it's a
Mhm.
distraction. It is.
Correct.
Do they have to put that in their FDD if they default someone?
Not if they
Okay.
default, but if a franchisee initiates some kind of
Extra.
litigation
Yeah, okay.
against
Oh
them,
yeah,
and then if they
litigation's always in the FDD.
yeah, and then
Yeah.
if a franchisor initiates a lawsuit, they have to disclose that as well.
Yeah. So
So
I don't want people to be
you
scared
can
like
avoid it.
yeah, they're not looking to default you for a
No,
late payment one time. Like that is
not
not
at
their
all.
well, if they're a great franchisor, that's not their go-to. They're not well, and Brian Schnell from Fagray will always say, if you are pulling out your franchise agreement to have conversations and work things out with your franchisee, that is not good behavior. You are really trying to
Mhm.
focus on that relationship before that agreement comes out. So,
Oh, absolutely,
yeah,
and that's why
yeah,
I
yeah.
I try and not get involved if I don't have to.
Yeah, right. Yeah. Okay.
It's like
All right.
telling my 2 kids to work it out.
Yeah. That's right. Oh, that must be so fun to have a lawyer as a parent when you're fighting with your sibling.
Oh my gosh. Side note, I was just talking to someone about this the other day because every time my kids ask for more screen time, I make them negotiate with me. I'm like, "Why should I give you more screen time?"
That
So
would
my
be
kids
done
are
for
gonna be
me.
insane. My kids are gonna be insane.
I love it. All right, so let's talk about transfers and exits. So we
Mm,
really try
okay.
and coach people that are just looking to get into franchise to think about that exit strategy from day one. Not enough people do that, and
Yeah.
of course it can change over 5 or 10 years. But what does the franchise agreement usually say about when you can sell your business and any red flags that you would give the audience to consider when looking at those?
So the transfer condition or the transfer definition is usually incredibly broad. It is usually um, covers any kind of assignment that you could think of. So it's usually any assignment of the franchise agreement, any assignment of any rights under the franchise agreement that the franchisee has, but also any change in ownership. Um, Not necessarily it could have a threshold, so you could transfer 5% to someone else or something like that. But typically it is any change in ownership. So the transfer definition is incredibly broad. So it's important to know that you really cannot make any changes without the franchisor's approval.
Yeah.
Um, so understanding anything that you may want to do. So if you sign it as an individual, create an entity, that's technically a transfer. Now, a franchisor is not going to gawk at you assigning to an entity that you wholly own. But if you are working on tax structuring and creating trusts or anything like that, that's just something you have to think of in connection with the franchise agreement and making sure that you're
Or
complying with.
bringing a partner into your business.
Absolutely.
Yeah.
If you're intending to bring someone else, understanding that that partner is probably going to have to sign the personal guarantee, the same thing that you did, and making sure that person is on board with that.
Yeah. Well, and they'll probably do all the same things they did for you when you went through that process. They're going to do
Mhm.
checks on you and that person. So it's basically starting from scratch with that new person you want to add.
Absolutely. And
Yeah.
then the red flags that I would say are similar to renewal. There's going to be a renewal fee. I would say maybe you can ask for an exception for if you're transferring to someone already within the system.
Mhm.
So that's a good way to reduce the cost because again, I tell my clients that the transfer fee is not a moneymaker. It is to cover your costs in connection with approving the transfer. So this unit is already open and operating. So the costs are slightly less than a brand new unit that you have to get open and operating. However, if it's a new system, if it's a new person coming into the system, you still have to train them, you have to approve them, you have to go through all of those things to make sure that that it's a good person for the system. And also understanding that you don't have the free discretion as you would if you had a separate business not associated with a franchise to sell to whoever you want. The franchisor still has that overarching approval of the person. And for good reason. You can't just sell to someone that they don't know. They have to it's the same approval that this person obtained in order to start operating the franchise.
Okay, so I think it's a little bit different from what you're talking about with the approval process, but I want to talk about the right of first refusal.
Yes.
So that's I think a little bit different. Can you just kind of talk through what the right of first refusal means to a franchisee that's signing this agreement?
Absolutely. Um, Typically, the franchisor will have a first right of refusal if there is someone that wants to come and buy your business. Typically, it's any portion of your business. Now, franchisors are really not in the business that I'm aware of buying portions of an entity of a business. So it's usually not, but that right is still in there, and they still do technically have that right of first refusal for that portion of the business. So it means that if you have a third party buyer that comes in and wants to purchase your business, the franchisor has the option to buy that business first on the terms that were offered to you by the third party. So they can step in and buy it at the same terms that the third party would. Now they have to match the terms, so you're typically not getting any less money. They can usually substitute cash or differing payments in lieu of cash in the event that you're getting an all cash offer. So looking at the terms of the ROFR in that way to make sure that you're comfortable with it is an important thing to look at. Because I would say time value of money, you have to match the offer exactly as is. You can't substitute a promissory note or a different payment structure if this person's going to offer me cash up front.
Okay, I think
And
that's a good.
typically it has to be accepted within a certain period of time. And then if the franchisor waives its right and they don't want to exercise it, then typically the franchisee would have a certain period of time in order to close the deal afterwards. But knowing that sometimes buyers get scared if there is a ROFR and you don't want to lose that buyer. So making sure that that time period is rather quick if the franchisor ultimately does want to exercise, and then the time period within which that they have to give you an answer should be really quick.
Okay. First time I've heard that acronym. So ROFR is right of first
Rover. Oh,
refusal.
yeah.
Look at
Yeah.
that. Little legal lingo for us. Okay. All right.
Yeah.
All right. Let's talk about termination clauses. What are the most common grounds for termination? Anything that would surprise a buyer that's reading this agreement?
I typically, as you can imagine, draft these termination provisions very broad. They usually come in buckets, and the buckets are usually immediate term without notice. So think um think fraud, think transferring without approval, think bankruptcy, kind of these different things. There's a second bucket of termination immediately with notice. That's one you really have to watch for because that one is usually pretty broad, and that is one where you'll probably want to revisit or at least ask for concessions or a cure period for some of the terminable offenses. I've seen failure to use approved products, failure to use approved suppliers, um, kind of what I would still deem a pretty big deal. But if you do it once and you cure within a short period of time, then that should probably be allowed. And I think that franchisors are more apt to give a little bit of wiggle room on that. But I've seen agreements that have 40 terminable clauses. And it's important to read kind of each one of those and understand whether there's a cure period or not. And then the last bucket is
Well,
termination.
just want to pause right there because
Okay,
I was going to explain.
please.
The
No, go ahead.
cure period is you've done something wrong. Here's your opportunity to make it right. Correct?
That's exactly right.
Okay.
So the franchisor does have to put you on notice if they are trying to terminate. So the agreement will say, um, you will be terminated if you fail to cure this thing within the cure period identified in the default notice, and the franchisor does have to provide you formal notice of the default and then formal notice of what you have to do to cure. So it'll outline what it should.
Like a
It
PIP
should
plan.
outline what's that?
It's like a
A
PIP.
PIP.
Yeah.
That's exactly what it is. It's exactly what it is.
Yeah.
So it'll say you have to do this, you have to do this, you have to send us written confirmation that you've handled these things, and then it has a specific time period within which you are required to do so. Now
Okay.
there are state laws that also regulate when a franchisor can terminate, can refuse to renew, or can refuse to approve a transfer. So some of the time periods in the franchise agreement may differ based on what state you're in. So think California, for example. They have a statute in place that gives longer cure periods for a lot of the terminable offenses. So making sure that you understand your rights under state law, in addition to what the franchise agreement says.
Okay. So those could be two different things, and you would have to call.
Correct.
Okay. Got it.
Mhm.
That's why you should have an attorney help you with this.
That is why you should have an attorney, not only an attorney, a franchise attorney,
Yes.
which we'll talk about a little bit later, but a
Absolutely.
franchise attorney that understands the nuances of the franchise relationship, the regulatory scheme, all of these
The
different
state
parts of
laws.
this.
Yeah.
It's hyper specific
Yeah.
area of
Yeah.
law.
We at Franchise Business Review are always looking for new ways to support people who are curious about investing in a franchise. That's why we created the new Food and Beverage Sector Report. If you're curious about the food and beverage industry, you've got to download this free report on our site. This will give you insight into what this industry is like, from salary to how many hours on average franchisees work per week. You need to have this resource. Visit franchisebusinessreview.com/food to download your free copy today.
Did you cover all the termination buckets? Because I know I stopped you for the cure period. Did we hit them all?
Um, Usually I see a bucket for termination with a short cure period, and then a termination, anything else 30-day cure period.
Okay.
So those are kind of the last buckets that I see, but making sure that those are all in line. And if you want a cure period for one of the offenses that are in the earlier buckets, making sure that you understand exactly what your cure period is. So, A good one I see is failure to open on time. I often see it that it's terminable upon notice without a cure period. That's a pretty easy one that you can say, so long as everyone is progressing towards the opening and you're doing everything using commercially reasonable efforts to open on time. If there's a delay because a permit is delayed, things happen. We know this. Um, so that's a good one to ask for a cure period, but just making sure that you understand what those are.
Yeah, and that I think is also really aligned with what we talk about is franchisors really sometimes want to focus on these multi-packs or these area
Yeah.
development things, and they'll have a
Mhm.
schedule for you to open. And it would be great to kind of get an overall industry number of how many of those actually happen on time. But
That'd be really
it would
interesting.
be really, really interesting because again, you should ease into this and you want to make sure one location or territory is really up and running and successful before you keep putting more money into it. And some franchisors will really hold you to that timetable, but others will allow you more space as long as they see that that effort is focused on growth for them, because otherwise they're going to
Absolutely.
yank it back and sell it to someone else.
Absolutely, because they
Yeah,
want you to open within that period of time and be able to penetrate the market
right.
and sell within that area within a quick period of time.
Yeah,
And I mean, circling on the multi-unit versus a single unit purchase in and of itself, both offerings will be described in the FDD. The multi-unit offering is typically a separate form of agreement that has a time period for payment of the fees, a time period for openings. If you don't have experience within the industry in which you are buying, definitely think twice about purchasing a multi-unit because you don't
great
know
advice.
exactly what you're getting into. I mean, if you've operated Dunkin' did going back to the examples before, if you've operated Dunkin' forever, you leave the system for whatever reason, you're after your post-term non-compete, whatever it may be, and you want to open Aroma Joe's. You have the experience necessary to understand kind of what it takes to operate a coffee shop. But if you're brand new to one of those two systems and you sign up to open 5, 10, whatever it may be within a 5, 10 year period, that's aggressive,
Yeah,
unless you have a full built out team
yeah,
that's gonna help you open all of
yeah,
those.
absolutely. Okay. So let's talk about again, thinking about the end, just being aware, educating people.
Mhm.
What happens to the business if the franchisee is terminated? What happens to the equipment, the lease, the customers? How does that look like? And is it outlined in the agreement? But what should the franchisee expect if that happens? And we're hoping we're doing enough educating up front that this is not going to happen. But again,
Yeah,
just want to
right.
share it.
No, of course. So typically the franchisor is going to say, I'll start at the customer level because each one is a little bit different.
Okay.
So typically the franchise agreement is going to say that the franchisor owns all of the customers, no matter what kind of business you operate, whether it be the social media followers that you have for your brick and mortar, your customer list, your loyalty program, if you're service based, all of the customers that you've ever serviced within your area, those are typically owned by the franchisor, which means you have no right to them post term. And the franchisor does not have to pay you any amount of money to continue to service those customers within that period of time.
So typically, do you see the franchisor, the corporate team will come in and run that location until they're trying to find a new operator for it? Do you see them shut the door? What is most common that you kind of see when there is a termination?
So it depends on the offense.
Okay.
So if it's one where they have to if it's a food issue, a public health and safety issue, something like that, and the corporate team has the capacity to go in and operate, then I will see that because best case scenario is for units to stay open.
Right.
A franchisor does not want closed units under almost any circumstance
Yes.
unless they absolutely have to. So their best case scenario is to do some workout with the departing owner. So say, hey, you're in default, you're not meeting your minimums, you're not doing XYZ. We don't think you're a good fit for the system anymore, but we want to give you the opportunity to get back part of your investment. So we're going to give you 6 months to sell. That is best case scenario.
Yeah.
So that still gives the franchisee an opportunity to recoup some of it because if they terminate without giving that opportunity, then you could lose everything. The franchisor likely has the right to step in and operate and manage during any default. So making
So
sure that
so
you
you default, you lose everything inside that building.
could.
Could.
potentially.
Okay, could.
Um, this is a really fact-dependent analysis as to whether the franchisor should go in and operate, because some states, again, only allow you to operate in an interim fashion for 30, 60, 90 days without checking in with the franchisee during that period of time. Um, but in states like the Midwest, like Ohio, where I'm from, there aren't restrictions on that. So they could go in and take over the operation, take all of the funds, and then take a management fee on top of the fees that you already have to pay, royalty fee, tech fees, ad fees, all of those things. Um, so they get compensated for going in and operating. And what they can also do is say, okay, we're going in and operating because it's terminated immediately. They usually have a right of first refusal to purchase the equipment. So you do own the
Okay.
equipment. If you have a brick and mortar, you buy ovens, chairs, tables, whatever it may be within the unit themselves. The franchisee does own that, and the franchisor does have to compensate for those items. However, if you have other debt, they have the right to satisfy that debt first. If you have other creditors, they have the right to satisfy all of those things first. And then the valuation is usually outlined in the franchise agreement themselves. I feel like I'm giving away all my trade secrets here for what I draft. The valuation is typically outlined in there, and it's usually fair market value, depreciation, depreciable um, value, and it's usually the lesser of those two things. So the franchisor is going to choose the valuation that
Right.
benefits them at
Right,
the
of
same time.
course. Yeah.
So you're not getting the exact amount that you paid for it,
Well, and if you're
particularly
leasing that equipment and you don't own it, you're probably
correct.
not gonna see anything after that's all
Exactly
taken care of.
correct. But then
Yeah.
you also have to think on the other side of the coin, the franchisor is stepping in
Yeah.
and taking over the operation. If you have years left on your lease, that's a liability that you could technically be responsible for,
Yeah.
just like the franchise agreement. And tying into one thing that you always want to look for is whether there is a liquidated damages provision. So at a high level, a liquidated damages provision is a contractual right that the franchisor will put in there because for a termination of a franchise agreement that ends prior to the end of the term to compensate the franchisor for what they deem the benefit of the bargain or what they were expecting to get out of the entire term of the franchise agreement. Typically, depending on the type of business and the state, it's enforceable to a certain extent. So usually not more than 2 years worth of royalty fees and ad fund fees.
Okay,
But
that's what
think
I was
about
gonna
how
say
much.
is I was gonna put it into, like, you signed a 10-year agreement, they want royalties for 10 years. So if you get
Yeah.
terminated in year 5, they could ask for 5 additional years of royalties, and you're saying typically a state comes in and says it's up to 2 years.
So typically, in the franchise agreement, the contractual right, what I advise my clients is you do the lesser of 2 years or the remaining amount
Okay,
under the franchise agreement.
perfect.
5 years is never going to happen.
Yeah, yeah.
Yeah, I
Well,
mean,
and if the
help
person's
me on that,
terminated,
but
most likely there's money issues, so it's
well, and that's the other thing that I talk to my franchisor clients about, is this even worth it? What are you going after? You're going in to operate because they weren't able to operate. You're
yeah,
really going to go after them for liquidated damages? And
yeah,
particularly when you're in that scenario, the franchisor is getting access to the unit and is able to operate. So, like, how much are they actually
yeah,
losing outside of their expenses that they're incurring?
yeah, yeah,
So looking at that, seeing if the franchisor will remove that is one of the things that I would say,
is negotiable
at the
or
top.
to ask. Okay, so
Oh,
liquidated
absolutely.
liquidated damages, is that how you stated it?
Liquidated damages.
Okay.
Either removing it in its entirety,
Mhm,
limiting it 6 months, limiting it in some fashion, because you will be signing a personal guarantee
mhm.
attached to this agreement, and that means you, in your individual capacity, are liable for any and everything under that agreement,
That's right.
including that liquidated damages clause.
Yeah, and we're hoping that no one ever gets to this point, but again, this is
No,
just knowledge.
never. Yeah.
All right, let's talk about non-competes. Almost
Oof.
every franchise agreement has some kind of non-compete. What do you think is reasonable, or what would be a red flag that you see under this area?
So it's so funny that we're talking about this now because I just posted about
I
Virginia's new
saw
law.
that. because my
that
family's in Virginia, so I saw that post.
Oh, yeah. So California has always had a very strict approach to non-competes, but now Virginia has outright banned post-term non-competes in franchise agreements, which so like my whole team is like meeting about it today as to
Yeah.
how to approach it, but it's another state that's considering
So like in
this.
in Virginia, technically, I could own a Dave's Hot Chicken and then go buy a KFC. I pulled that old brand out.
So interim, no.
Okay.
Post-term, yes, you
Okay.
would be able to do that. So
Crazy.
essentially, it's giving people the right to continue to earn a living after the term of this agreement, which I
After the
fault
term.
that
So not while they're
after
in it,
the
because I was like, that is so scary because then you can like basically
no.
take people's trade secrets from the brand across platforms. Okay. So it's post.
But you could turn around the next day and do the same thing though,
Yeah.
which is
Yeah.
the crazy part.
Oh
And I
my
mean,
gosh.
I know this could be a whole separate podcast on this because you still have rights with respect to your confidential and proprietary information, and that is still yours, and they cannot technically use that. That's why owning the customers, owning the customer list, data, everything around that stuff is so important. But it's very difficult to prove without a non-compete in place. Like it's so hyper fact specific. You have to tie directly parts of the manual that they are using in their new operations, and it's an expensive
Right.
endeavor
Yeah.
without that post-term non-compete. So typically, turning back to what so franchisees in Virginia, you're welcome, is what the answer is right now for them. But most so a non-compete is governed by state law, and it has
Okay.
to be reasonable with respect to time, geography, and scope. So time is usually no more than two years will be enforceable, lesser in certain states depending upon their approach to it. Geography, so making sure that the geographical scope of the non-compete ties to where the franchisee is actually servicing. So it has to be tied to something. I've seen it too broad and unenforceable where it says you can't open anything within your local territory, within a radius of your territory. But then also, you can't open anything within a radius of any other unit within our system. That's typically where it gets too broad and unreasonable, depending upon the state where it's being enforced.
Okay. So
Because
what you're saying is like I close my doors and then I couldn't have a competing brand in a market that's close to where that brand A exists.
correct.
Okay,
You live in
understood.
Florida, you own your
Yep,
unit there, you end whatever relationship you have there, you move to North Carolina, but the system still has units there, you wouldn't be able to open within a
understood.
certain geography
Okay.
of those as well. But because that's a moving target,
Yeah.
so a non-compete has to be reasonable when you sign it. It has to be definitive when you sign it. So that's the problem with tying it to something in the future is that you have no idea where you're going to have units in 5, 10 years when this relationship ends. So unreasonable to ask someone to agree to a restriction that they don't know about at the time that they are signing. So oftentimes I see that as one where it's not going to be enforceable.
Okay. So what about Megan, if I own I'm going to use this in the services space because there's so many platform brands now that own multiple brands. If I
Yes.
own a floor company that
Mhm.
might be part of a larger brand system, is there something in the agreement that tells me I can't open up a plumbing company that belongs to someone else?
That is a really good question. The answer typically is no, because the
Okay.
franchise agreement has to be, or the non-compete has to be tied to the business that you're actually operating. So if you don't have access to the resources that the plumbing business would offer to you, then they don't really have anything to protect against. There's
Okay.
not an interest that the franchisor is protecting against. However, I will say that some systems that have the platform brands that do see that activity may refuse a request for you to expand. So, in the event that you are private equity buying a multi unit operator within a system that has a platform brand, and you say, well, we may want to expand in the plumbing area, but we don't own that right now. But we want to maybe own a competitor of you in that space. Well, the franchisor can say, okay, if you want to do that, you're allowed to do that, but we're not going to sell you any more units because
Yeah.
we don't like the optics of that.
Yeah.
So I've seen that approach in the private equity space, particularly. And it's really interesting to see, like, you can do that, but we're not going to sell to you anymore,
Yeah.
which private equity, all they want to do is grow. They want to acquire more. They want to scoop it all up. Mumbos, that's what they want to do as well. So making sure that you understand that.
Yeah. Yeah. And so just if you haven't listened to past episodes of Mumbo is a multi-unit, multi-brand franchise owner. So they usually go in with this idea of what they want to own. And typically you stay within your parent brand because it makes sense. You
Typically.
have relationships there, you know them. So it's rare, but you want to understand that before you sign anything.
Absolutely. And on the negotiation side, the more power you have, the more money you have, the more likely you are going to be to gain some of these concessions that we're talking about here.
Interesting.
Oh yeah.
Isn't
Oh
that
yeah.
the way here in the United States?
Welcome to the US, baby.
Oh goodness. All right, that's another episode too. Okay.
That's another episode.
All right. So dispute resolution and governing law. This is the last area that I want to dig into.
Mhm.
Most franchise agreements require arbitration before litigation or rather than litigation. Is that better or worse for a franchisee? Is it how do you look at that or how do you explain it to people?
So, based on the litigator you talk to, you're going to get different answers about what method is better, honestly. My preference, not a litigator at all. Um, arbitration has its benefits. One, you typically get to choose the arbitrator. So you get to choose someone potentially that has experience in the franchise industry. So it'll have a procedure that'll outline both parties will typically get to submit people um, to be the arbitrators, cross off people that they don't like. Typically it's going to be franchisor crossing off the franchisee side people like but you eventually get to a person that has knowledge and industry knowledge about what a franchise is, what types of disputes are typically what come up, and then how they are resolved. So that's a benefit. It's usually quicker than court. Anyone who has experience going to court for literally anything, it can take a very, very long time to get anything done.
Yeah. It usually
Uh,
costs less too, right? Arbitration costs less than or no?
no, it usually
Okay.
costs more actually
Oh, okay.
because you have to pay the arbitrator a fee
Hmm.
per hour, which you don't have to pay a judge, your taxes pay that. And then you typically have to reimburse that person for all expenses. So
Okay.
you're paying for their time to review any of the discovery prior to the arbitration, any mediations prior to that, and then any day of cost as well. So typically it's actually more
Okay.
expensive. But you usually get a result that is quicker. One thing I'll say about arbitration is that sometimes an arbitrator is more likely or more apt to find a resolution as opposed to finding the right resolution. So
Yeah.
they're more likely to what I say split the baby
Yeah.
as opposed to really determining what is right.
Yeah. Okay. That's interesting. Okay.
Yeah.
So Megan, what if I live in Maine and my franchisor's in Texas? Where does that arbitration usually take place?
Typically in Texas, unless you have a
Okay.
state law that says the governing law is the law of this state, and you have to have whatever arbitration, litigation, whatever it may be in the state where the franchisee is. Think California, Illinois.
Okay.
There's a couple of states. I don't know them all off top of my head, but there are some states that do allow that to happen. And
Okay.
then even if you choose the law of the state where the franchisor is located, states like California, Illinois, Washington do not let you, as the franchisor, say that the franchisee doesn't have rights under the state laws where they are operating. So California and Illinois, Washington have state laws that protect the franchisee against termination, differing ends of the relationship. So they would still be able to avail themselves under those laws in the event that there is a dispute.
Okay. All right.
So, as a franchisee, knowing and understanding your rights under state law is so hugely important.
Yeah. Well, and this is why we're going to go to the comment you said before is this is why you need a franchise attorney to help you work through this because every
Yes.
situation is different. Okay. You went through a really great job of each part of those and red flags as far as what you feel like is negotiable versus not. Is there anything else that we didn't talk about that the franchise buyer should be thinking about that they should ask for or negotiate that we didn't cover?
Initial fees are always easy to negotiate if they're a smaller system because sometimes they just want to get people in the door. So I would say, that's kind of a not long lasting change. So it's just a one-time thing. You're like, I want a deal on the initial fee. I want a deal because I'm operating in a new market
Yeah.
that you've never been in before.
Mhm.
I deserve to get a little bit of a discount because of that. That's an easy one to ask. But otherwise, a lot of the agreement is going to be non-negotiable and standard for
Yeah.
good reason,
Yeah.
frankly, because you want consistency of the brand. You want the experience in Ohio to be the same in Maine. You want those to be the same. And without the structure of the franchise agreement in place, not only is the franchisor not protected, but the franchisees are not protected either.
Right. And you wanna know everyone coming in after you is in the same, held to the same standard as you are, so that's great.
Mhm. Oh, the only other one that I would add is if it's a brand new system, they don't have a brand fee yet, and you ask, well, what are you going to do with a brand fee? There's 3 units within the system. Like, well, how are you going to spend it and all this stuff? Asking the franchisor to not start a brand fund until you have 5, 10 units, or it actually makes sense to start collecting it. That's usually one that I've seen as well.
Okay, that's a good one. Okay, so let's talk about I mean, we've already talked about in other episodes, but why do you think, I think we've covered it, that you need a franchise attorney versus just an attorney to help you through this process?
Great question. So the first thing is a business attorney that has no exposure to franchising will not understand the typical terms in a franchise agreement. They may try and completely redline the 60-page agreement, waste hours and hours and hours of time trying to understand why this agreement is drafted so heavily in favor of one party over the other,
Yeah.
where you get someone who has experience within the industry, completely knows and understands, okay, like this is standard, but here's what you want to know about it. So a lot of, like I said in the beginning, it's just understanding what you're signing up for and trying to make those small concessions and asks within the document. So I think oftentimes when I've seen a just a business attorney that looks at a franchise agreement, they send back this red line document and I immediately send it back. I said, I'm not even looking at this. This is not how we do this. Every change we make is in an addendum. We're not going to add reasonability everywhere, substantial everywhere, material everywhere. We're just not going to do it. So go back and tell your attorney to give us an issues list and then we'll talk.
Yeah. So you're just
Um
wasting your time and your money if you
I
are starting with someone that doesn't really understand what is negotiable versus not.
Correct.
Yeah.
And then that attorney may not also understand all of the rights that we were talking about earlier under these certain states where you have protections in place and making sure that you understand what those rights are in the event that there is a dispute, in the event that making sure that any addendum or any addenda that needs to be signed in connection with operation in those states is actually signed and that the agreement reflects whatever state laws are in place.
Yeah. I mean, and I would always recommend that people use the International Franchise Association, go to their website to make sure
Yes.
that the legal counsel is a member, because I think that's the best way to show that they're engaged with our industry, which is very complex. And I know that we have a legal symposium, like there's always changing law, so it's really important that they're active in this community. Are there other questions you would recommend people ask their attorney before hiring them to just make sure that they really know franchising?
Yeah, I would say I think the engagement within the franchising community definitely is one thing. I would say other experience and other systems that they have worked with. So oftentimes, so like I have referrals for franchisee side attorneys that I typically send stuffs to. Like we're at opposite ends at times, but I also know that they are reasonable
Yeah.
people. So even if you ask the franchisor themselves if their attorneys have recommendations, they will probably give people that are reasonable, probably not the people that are going to fight for every single little thing, but that will fight and get you things that will be most, impactful for you.
Is it important that they're
Um,
in your state? Does that matter?
does not matter so
Okay.
much because the franchise world is rather national based. None of my clients really are based in PA. So because of the national scale of just franchising just in general. But if you're a one-off shop and you're operating in Virginia, it probably could help to hire a Virginia attorney for the sheer fact that you're probably going to need other help and assistance in connection with operating the business. And if that person is also a franchise attorney, that could also be
Oh,
a good
that's a
thing,
great point.
but
Yeah.
certainly not a necessity.
Okay. Is there an average cost or time that you think people should expect to pay for help around this franchise agreement review?
I typically say $3,000 to $5,000 to review the FDD, review the franchise agreement, and then put together kind of a list of issues is what I would request if I was a franchisee asking my attorney to put something together, because the franchisor is going to look at that list of issues before you even start to put pen to paper on any amendment. So understanding kind of what your pressure points are and being able to put that in writing. But I would say $3,000 to
Yeah.
$5,000 is a pretty
Which
good
can seem
range.
like a lot, but if you look at your total
Mhm.
investment into this and you think about that 10-year term,
Absolutely.
just do it.
I know, I can't, like, it seems like a lot up front, and there's so many costs to this business up front, any kind of business, frankly, but especially a franchise business. You're looking at hundreds of thousands of dollars,
Yeah.
sometimes $1 million that you're pouring into this business, like your livelihood, your retirement funds are going into this, and you're not gonna spend $3,000 to $5,000 to make sure that you're protected, I think,
Yeah.
it's money very, very well
I
spent.
agree. I agree. Okay. So this has been unbelievable. It's a nice meaty episode. We got lots of free legal advice for these buyers, but
I
we are
know.
not saying this replaces working with a franchise attorney
No.
by any means. Okay. One piece of advice that you would give someone that's about to sign a franchise agreement for the first time, what would you say to them?
Oh my gosh, that's such a good question. Do your research on the culture and values of the system you are buying, because it's one thing to be in line with the operational structure, but it's an entirely different thing if your values don't align with the people at the top. You will find yourself at odds at times, and just looking at their experience within the industry is so important. Looking at their terminations over the last few years, I know this is like multiple things of
No,
advice,
this is
but,
great. Yeah.
um,
Well,
terminations over the last
terminations
few
and
years
litigation, that's both in the
and
FDD.
litigation,
Yeah.
calling all of the people that left the system during the last year. Why did they leave the system? Were they
Oh,
happy
I
that they
think
left
that's
the
the first
system?
time people have given us that advice.
That can't be
Mhm.
right.
Yeah.
Oh my gosh. So one
They're
thing I
also
look at,
listed in the FDD, but yes.
they're listed in the FTD on an annual basis, and it's what I warn my franchisor clients about is that these people have to be listed in the FTD for a year, and they're gonna talk. Unless they're under some kind of settlement agreement, they're gonna talk, and they're gonna be very honest, and if they leave via a transfer, they're probably pretty happy, but if they leave via a termination that was tumultuous or whatever it may be, they're gonna be very unhappy, but it's a good indication of what kind of system it is, how it's growing, how it's developing,
Well, and how
and
they're
why people.
protecting the brand. A termination is not
Absolutely.
always a bad thing. So, yeah, understanding
Correct.
that. That was great.
Absolutely.
Great advice. First time advice, I think. I might be wrong, but all right. This was amazing. And just to remind all of our listeners, our website is available to help you with resources to evaluate franchise brands. We really want you doing your research and talking to franchise owners before you ever get that franchise
Yes,
agreement in your hand. So that's available for free. And also, too, just going back to episode 9, Tom Spadia, where we talked about the FDD dive, I think that goes nicely with this franchise agreement talk.
absolutely.
So thank you for joining us, Megan. This was amazing. We
Oh,
appreciate your
thank
time
you.
and your
Thank you.
expertise.
Of course.